Parliamentary staff will no longer enjoy immunity from being served with civil proceedings within the Parliament after Section 3 and 11 of the Parliamentary Privileges Act were found to be inconsistent with the Constitution.
Declaration B and is hereby issued decreeing that Section 7 and 11 of the Parliamentary Powers and Privileges Act, Act number 29 of 2017, are inconsistent with and contravene Articles 1, 2, 3, 10, 19, 20, 21, Sabbatical 1, 22, 23, 24, 48, 50, 93, Sabbatical 2, 94, Sabbatical 4, 159, and 258 of the Constitution of Kenya 2010. 2. And Declaration B and is hereby issued declaring that Section 7 and 11 of the Parliamentary Powers and Privileges Act, number 29 of 2017, are unconstitutional and therefore null and void.
In a ruling by Justice John Mativo, any decisions made by parliamentary committees can now be challenged in court.
The primary duty of the courts to uphold the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. And if in the process of performing their constitutional duty, courts intrude in the domain of other branches of government, that is an intrusion mandated by the Constitution.
The court found that by excluding decisions made by Parliament from judicial review, the Act discriminates a section of Kenyans from exercising their constitutional rights as enshrined in the Constitution. The disputed law, which was assented by the President in July 2017, was challenged in court on grounds that it grants Parliament super immunity. Justice Mativo, however, defended the decision by the President to assent the bill into law, saying the head of state acted within his powers as provided for in the Constitution.
The immunities that Parliament had arrogated itself, which were unconstitutional, has now been determined as unconstitutional. Those immunities does not exist, and anybody can serve Parliament with a court process even if parliamentarians are in session. Secondly, anybody can challenge decisions of the Committee of Parliament, including the laws that are passed by Parliament.
And now Kenya leader Martha Karua suffered a legal setback when the Kerugoya High Court dismissed her application to include new video evidence in the hearing of her election petition. Justice Lucy Gitari ruled that the application was irregular and lacked basis since the evidence ought to have been included in the main petition. Karua had claimed to have submitted a flash disk with evidence of electoral officials tampering with the election material, only for the disk to go missing. Finally, former government pathologist Moses Njue, who has been charged for stealing a heart from his patient, has moved to the High Court seeking to stop criminal trial at the Magistrate Court. Njue, who was charged alongside his son Lemuel Mureithi Njue, are accusing the Office of Director of Public Prosecution of selective prosecution and investigation. Ben Chumba reporting for Scales of Justice.